Good evening, member. My name is Alexander Paterno from Bridges, Chauvel and Allenby, and I represent the applicant in this matter, Floriards Proprietary Limited. If you'll remember, my client is a company conducting experimental research on the new blue Camellia japonica flower, which has huge market potential in Asia and South America. Unfortunately, the Office of the Gene Technology Regulator had recently denied my client's business license renewal, and after reviewing its statement of reasons dated the 3rd of June, we believe an avenue of appeal exists under Section 5(1)(a) of the ADJR Act, on the basis that natural justice was not afforded to our client. We will seek an order of review where the decision is made again, but this time in accordance with the principles of natural justice. The starting point is Section 5(1)(a) of the ADJR Act, which says that a decision must be made in accordance with natural justice. In Kiowa and West, it was upheld that natural justice incorporates two things: the fair hearing rule and the bias rule, and this is afforded to anybody with a right, interest, or a legitimate expectation. The facts here strongly mirror the facts in FAI and Winnicke, where the government denied a business license to an insurance company on the basis that its parent company was experiencing financial struggles. There, it was held that in such circumstances, a company held a legitimate expectation. My client, like FAI, did so because they believed their business would continue indefinitely, so long as it proved successful and it was conducted properly. In such circumstances, a company has a legitimate expectation that its approval will be renewed unless such good reason exists for refusing to renew it. The fair hearing rule was breached because my client was not provided the opportunity to see the materials or be heard. Firstly, before proceeding with the decision not to renew my client's license, my client should have had an opportunity to see the materials. My client should know the entire case against them and be presented with the reasons for the decision and a chance to clarify such issues as whether or not the flower even posed a genuine environmental threat, the likely impacts on health and safety, the effect of the minister's statements, or any other basis upon which the decision was made. They need to see the entire materials and then they need to respond to them. Furthermore, using confidential departmental policies as a basis of the decision breaches my client's right to see the materials. My client is further disadvantaged by this because information was made available to the decision maker by one party behind the back of my client. More information is needed, but presumably these confidential departmental policies do not contain matters of national security or confidential information of another party, and as such they should either be revoked as a basis upon which this decision is made or disclosed to my client so they may respond to them. Case in point, Kandar and the Government of Malaya, where Lord Denning's judgment at page 337 stated that a decision maker must not hear evidence by one party behind the back of another. Secondly, the right to be heard was discussed in Cooper and Wandsworth Board of Works and Kandar and Government of Malaya. In both these cases, government decisions made adverse to a person's property were lambasted by the judiciary because those decisions were made without having first given that person the chance to respond or be heard. The bias rule was breached because there is a reasonable perception of apprehended bias on the part of the decision maker. Firstly, apprehended bias was discussed in Ebner and Trustee and Bankruptcy, where at pages 344 to 345, a test was developed to assess whether the possibility of apprehended bias existed. This test asks whether a fair-minded and lay observer would reasonably apprehend there was a real possibility that the decision maker may not bring an impartial mind. Here, there is a logical connection between directing a competing company which exports very similar flowers to a very similar market, being the camellias to Asia, and the fiat effect on impartiality. Specifically, that lay observer may reasonably apprehend that the decision maker may attempt to eliminate business competition by way of refusing to renew business licenses. Secondly, a pecuniary interest was held in Webb against the Queen as being one which is generally disqualifying. Judge Finkelstein implicitly agreed with this in Kirby and Centro Properties. There, Judge Finkelstein recused himself from deliberating over a dispute over which he held a relatively small pecuniary interest. Here, the decision maker should have recognised that the conflict of interest is one where arguably he or she holds a relatively large pecuniary interest. As such, should recuse him or herself from deliberating over this matter in question. It is clear that my client had a legitimate expectation that their business license would be renewed. A right to appeal under Section 5(1)(a) of the ADJR Act exists because there was clearly a breach of natural justice, specifically the right to be heard and the bias rule. The fair hearing rule and the bias rule. We respectfully seek an order of review where the decision is made again in accordance with the principles of natural justice. Thank you, member.